to particularly the Swachh Bharat concept, which he has brought in nationally, again brought into the perspective of environmental perspective. Well, there is a huge war between the developed and developing nations with respect to various aspects. In a similar way, giving the philosophical ramifications a reality, the judiciary in India, in innumerable number of cases, has passed extensive directions to preserve environment, like Silicon Valley or valleys in Kerala or Chipko movement. We have number of movements to discuss. There is no end. In fact, in one of my papers, I have written long ago, that became true. In one of the judgments I found, the Supreme Court has quoted that music may be a beholder to somebody, give happiness, but at the same time, it gives noise pollution to others. We have to do this synchronizational perspective. The areas, though the Honorable Supreme Court and the Honorable High Courts and the Honorable Judges gave number of judgments, the establishment of the Green Tribunal, taking into various perspectives, all have come in, because Ratlam municipality case, followed by number of cases that have come in, a number of cases that have come in. But then why the environmental movement, both nationally, internationally, regionally, is not taking that up, at least in the Western countries and in America and other places, people have the consciousness to secure. In the eastern part of the world, particularly our country, we only talk lectures, we only deliver sermons, we only highlight in news channels, but we don't ban. Any government, any judicial dictator can come. Only reality will take place when people directly take part and ready to deal with those perspectives. And when that perspectives are taken into consideration, the perspectives that have been taken and the topic of today, that is the role of government and public in protection of environment. I think Honorable Justice has chosen a very crucial topic. Government always try to do its own perspective for various reasons. We are not bothered about parties in power. We talk of government, whatever may be the party in power. Government always do its own executive bit of mind for its own activities and concern. If we want environment to be sustained, Honorable Justice has given very clearly public participation. The role of public in the protection of environment is very important, which we are not doing. We have forgotten the ethos. We think that this earth and this world is ours. It's not ours. It is not. We have no right to have or to spoil this environment. If we see our own Chennai city, Justice Satyanarayana sir in one of the judgments a year back very clearly commented from the High Court, portals of the High Court, that by the time you develop Chennai, compare with Singapore, it will develop 100 years more. Then where are we? When we go to some of the places, you have a preservation, even in COVID-19, if you go out to the city of Chennai, everybody puts the garbage on the main road. And we put the garbage in the canal. Then we blame the government. Government onnu pannala. Enna thanni nikkudu. Even if mala varudhu, இப்போ மும்பைல கூட மழை வந்திருக்கு 3 நாள். நமக்கு சென்னையில வரப்போகுது சீரியஸா. Why the floods are coming? The garbage, the dust, the drainage pipes, everything government does. We throw it. How many times government also can clean? Government public should go hand in hand. We have to discharge our responsibility. The Constitution of India and Article 51A has given us the responsibilities and the name of duties. Unfortunately, we think only right. Everybody writes right to information, but everybody doesn't want a right to duty. Because every right is encompassed with duty, and duty, if you discharge, a right will come into existence. A right in rem, duty in personam. I think Honorable Justice has rightly chosen the topic. Duty is in person which needs to be protected. If that awareness could create, and I appeal particularly the role of educational institutions, particularly universities, and the departments of environmental science or ecology, whatever it may be, they should take the lead, not doing the research or promoting PhDs or LLMs, but to strengthen the students to the public and educate the public. This is a very vital task. Unfortunately, 90% of the departments in the country, only 10 to 15%, only 10 to 15% are doing. 90% of the academic departments, they may be great in research. Producing volumes and volumes, writing documents is no use. Because recently a survey came in Europe. You write hundreds of articles, thousands of articles. How many are going to read? But if you give street play, teaching techniques, teaching methods are changed. If you do role play, street play, create awareness, just started. I expect our Ambedkar Law University, particularly our Department of Environmental Science, to change the strategy from academic orientation alone to public orientation. This definitely highlights government means it is not directly government, minister, prime minister, chief minister will not come or municipal corporation will come. We are also part. A university is also. So this state also should evolve public groups with organizations like NGT, honorable judges and others as advisors, members. We have to constitute public benefit groups to protect the environment. And then definitely we can achieve a beautiful environment, a greener posture, and we can reduce the diseases like the COVID-19 and other things. The first director of UNDP has very clearly given us that we have not inherited this planet Earth from our forefathers, but it is the property of our future generations. That means it is our duty to give as better as we can, or at least the way we received from our forefathers. This statement of Mustafa K. Tolba, said it in 1970s, is a very, very beautiful statement, and this leads to deal with various perspectives. So, having said these are the various vital components that are there, looking forward, I'm highly thankful to Honorable Justice, in spite of the busy schedules, kindly accepted to share the opinion on a very, very vital topic. Public participation role of the government is very rarely addressed topic. People talk environment, Stockholm Conference, Paris Declaration, this declaration, that declaration, this conference, that conference. That's all developed law, but implementation part what we are doing. And I'm thankful for selecting such a wonderful topic. I think justice will dwell us more light on various perspectives. We are all eager to listen to you, sir. I'm extremely happy. And on behalf of the university, I once again heartfully welcome you and request you to please give our valuable piece of advice to us to implement. And as I stated, please guide us for the Ambedkar Law University is ready. I hope my colleagues, Dr. Balaji and Dr. Harita and Dr. Shittuvel in the environmental department, with our students contingent, the advantage of Ambedkar Law University compared to National Law School, we have excellent students, we have huge force of students. We will definitely do our discharge in the role of government in creating awareness to people. I hope our colleagues will come soon with the proposal immediately after the COVID and do cross small cluster projects on this and develop, and with the cooperation of my students and my faculty, I can assure you at least in and around the university in the new campus of Perungudi, we try to make the environmental friendly atmosphere. With these few words, I welcome you once again, sir. I welcome one and all heartfully for this memorable, wonderful morning for the excellent lecture that is going to be shared by Justice Ramakrishnan. Thank you. Thank you, one and all.
Thank you so much, sir. Am I audible?
Yes.
Thank you, sir. Thank you. From November, before I proceed, I would also like to inform all the participants that the YouTube link has been shared on the chat box and you can also watch us live on YouTube. I now begin. From November 2018 till date, Honorable Justice K. Ramakrishnan has been serving as the judicial member of the National Green Tribunal Southern Zone. Apart from the regular cases, Lordship has taken suo motu cognizance of several matters relating to the environment, ranging from pollution of rivers to encroachment of lakes, and has been hearing and disposing them off on a continuous basis. Lordship is indeed the apt person to speak about the role of government and public in protection of the environment. I now invite Honorable Justice K. Ramakrishnan, Judicial Member, National Green Tribunal Southern Zone, to deliver the lecture on today's topic. Welcome, sir.
Thank you very much. And good morning, everyone. Your beloved principal, the Vice Chancellor, TNS Sastri, Director Balaji, Harida, your HOD, and Shaktivel, HOD in charge of Human Rights, and student moderator, Aishwarya Lakshmi. Thank the COVID-19 period for a new innovation of sharing knowledge through, because unless such a situation arises, we will be always waiting for time of the speakers to come to the universities and places where they will have to travel and deliver the lecture. But now it has made so easy that the knowledge sharing is very easy, and we will have to thank, though lot of difficulties have caused on account of corona on health wise, and also our movement has been restricted, but innovations have been started, and that is one of the thing that has caused COVID-19 a progressive one, I can say. Really, when I was contacted by the university, I thought that instead of going on discussing on precedents and other aspects, it is always better to have a practical approach on a subject which will be helpful for everyone to follow. And really, my work has been made easy by the introductory speech made by Dr. Balaji and your Vice Chancellor and also Harida, by quoting Tirukural, where long back itself, the people who are thought of protecting environment is a basic duty of the general public. Let me start with my topic now, because, and also I think that what I want to talk on this subject is not based on any precedent. General thing that I have learned by studying the basic principles of environment and how far the government has got a duty and what is the duty of the people on the basis of the law that has already been provided, without quoting the sections, because I don't think that the time will be sufficient for us to go into those things in detail. So I will be restricting my speech on general aspects of environment, how it is being treated in olden days, how people were treating the environment at that time, and how it has been developed subsequently, and what is the necessity of the government as well as the people in protecting environment for a healthy life. First of all, we will say, what is environment? Environment deals with all aspects around us which has got impact on our day-to-day activities, including a study of animate as well as inanimate organism in the universe. Environment plays a greater role in human life. If there is any intrusion or over exploitation of environment, that will have a direct or indirect impact on human life, either by affecting the health or by denying the natural necessities like air and water. Environment has been defined under Environment Protection Act 1986 with an inclusive meaning as environment includes water, air, land, and interrelationship which exists among and between water, air, land, and human beings, other living creatures, plant, microorganism, and property. Further, the Act also defines environment pollutant means any solid, liquid, or gaseous substance present in such concentration as may be or tend to be injurious to environment. Environment pollution has been defined as environment pollution means the presence in the environment of any environment pollutant. How environment was considered in olden days. In olden days, people were treating nature as god or goddess. They were worshipping it as Panjabhutas, namely air, water, fire, earth, and sky. People had an apprehension that if any danger has been caused to nature, then it will trigger the nature, which would result in disaster affecting the human life itself. As rightly pointed out by Professor Harida, that is what we are facing during monsoon season in Kerala and other. Natural resources with abundant caution as they were aware of the fact that any over exploitation or deterioration of natural resources affecting the equilibrium of Mother Earth will have disaster in human life. They were very cautious in protecting the nature as they were very much aware of the fact that clean water, air, and environment are required for their day-to-day active life. Any scarcity of these will impact on the day-to-day life of the people. They were also loving other living creatures, namely plants and animals. Some of them they domesticated and used them for their purpose in their day-to-day life as well. Even they were respecting Mother Earth as well as animals as they felt that they were giving food and help them in improving their economic intimacy between human beings and animals, and they were respecting each other in order to have a smooth and healthy life. Vedic concept of environment. In ancient period, Vedas, Upanishads, and other Idigas Puranas insisted the necessity for protection of Mother Earth and environment. A verse from Rigveda signifies the importance of planting trees. It says, thousands, hundreds of years, if you want to enjoy the fruits and happiness of life, then take up a systematic planting of trees. How beautifully it has been said. How the nature is playing for the purpose of enhancing our longevity of life itself. Another verse says, do not harm the environment, do not harm the water and flora. Earth is his mother, I am her son. May the water remain fresh, do not harm the waters. Are we following it? It is a time for us to think. The Samavada, like other Vedas, also recognizes the importance of maintenance of seasons, cycles that are likely to get altered due to climate change owing to inappropriate human actions. The other Veda, there is a specific stoppage as to which means that one can take from the earth and atmosphere only so much one would give back to them. See, that gives the principle of public trust doctrine, where it says that you are only a trustee and you are not exploit the nature for your benefit, but it is for benefit of all. Narsimha Purana personifies trees are God himself. Varaha Purana advocates regular plantation as means of attaining moksha. It says, one who plants two pomegranates, two oranges, and 5 mangoes does not go to hell. So that gives the importance as to how you will have to create what you call green environment always, which is necessary for protecting environment. In Padma Purana, person engaged in unsocial activities and in acts of polluting is enjoyed in killing creature, polluting wells and ponds and tanks, and destroying garden, certainly go to hell. So that is a way in which they curse that that shows how you must be compassionate, not only to the animals, but also to plants, and also protect water bodies, which are playing a greater role in protecting your day-to-day life. Matsya Purana regards planting of a single tree equivalent to leaving a progeny of 10 cents. How beautifully they said how you will have to promote planting of trees and instead of destructing the same, because it says that it gives a pleasure of providing or catering 10 sons. If you provide one tree, that day is going to help thousands of people, that will give good air, that will give good atmosphere, which is necessary for the human being. It is mentioned in and they are never to be cut. Durga Sastadi says that so long as the earth has mountains, forests, trees, plants, etc., human race will continue to survive. So that also gives the importance of the existence of these natural resources. Which are a healthy atmosphere and which is forest superintendent and superintendent of forest produce to be appointed by the state for each state's forest zone, who will be responsible for maintaining the health of the forest, for producing the forest products to satisfy economic needs, and for protecting the forest to assist the wildlife. He gave a notion that new forests are to be planted at the time of creation of a new state on an unoccupied land and on the land suitable for agriculture. Thus gives an indication and forethought by the great sage, I can say, that whenever you are destructing nature, there is a duty cost on you to substitute with so much area that has been lost on account of our intrusion. Thereby, the forest cover will have to be protected. That should never come down. His directives on water specified that it was considered as extremely precious and as a collective and not as a private community. Fines were also prescribed for such activities that adversely affect the water bodies, such as obstructing or diverting a water course, or damaging the embankments, etc. He emphasized on efficient water management system and gave instruction as to how to do it as well. He also recommended several practices for conservation of natural resources. An analysis of thoughts of Kaudilya will go to show how he had foreseen the necessity for protection of natural resources and the role of the government in protecting the same, which he felt was necessary for the existence of human being itself. He had also foreseen the doctrine of public trust, sustainable development, and the precautionary principle, even at the primitive stages of development of administration and good governance. He always thought that it is not only the duty of the government, but also the duty of the public to protect, preserve, and conserve the natural resources, not only for the present use, but also for use of the future generation, thereby gave an idea of intergenerational equity, the concept which has become later part of international governance as well. Other religions, namely Islam and Christianity, also insisted the necessity for conservation, preservation, and maintenance of environment. According to the tenets of both Quran and Bible, it emphasized that natural resources are not only property of, and everyone is expected to act as a trustee to keep the natural resources for the enjoyment of the present as well as the future generation. They will have to act as guardians with a view to protect the natural resources against damage, destruction, and overexploitation. Environment evolution of environmental protection at international level and its impact on Indian scenario. In olden days, there was no environmental law as such or any law recognizing the right of the people to have clean environment. There were only common law remedies available under the tort for people to get redressal of their grievance when there was intrusion into the right of peaceful enjoyment of life on account of any wrongful or polluted environmental situation caused due to any wrongful act done by the others. He will have to move the civil court for damages if any damage has been caused to him on account of the wrongful act done by the neighboring owner, and the law courts were awarding compensation for such loss, apart from issuing prohibitory orders, preventing continuation of such wrongful act, and in certain cases, mandatory direction to restore the damage caused to his original position. Only during 1970s, the entire world thought of recognizing clean environment as a human right and realized the need for regulating the activities which are likely to affect environment. They were facing severe problem of pollution globally, affecting global warming and reducing the carbon footprint in the atmosphere. They realized the need for protecting the environment globally so as to bind the other nation regarding their responsibility to protect the environment so as to save the world from destruction. They also realized the necessity for protecting environment which is likely to be affected by the pollution on account of development activities which are likely to cause air, water, and noise pollution, which will have direct impact on the human health. They also felt the necessity for regulation of exploitation of natural resources like mining, forest, habitat, flora, fauna, and other development issues which will have impact on global environment. The environmental law as well as human rights laws were simultaneously emerged as a challenging problem, and this was recognized in the Universal Declaration of Human Rights 1948, followed by covenants of civil and political rights and covenants of economic, social, cultural rights, both in 1966. Multiple efforts followed thereafter classifying these aspects as first generation human rights, civil and political rights, second generation human rights, social, economic, cultural rights, and thereafter an expansive one as third generation human rights to a safe and quality environment, natural resources, development, sustainability, intergenerational equity, self-determination, etc. So after long lapse of 20 years, they realized that there used to be conflict between human rights law and environmental rights law, and they have been overlapping on each other. They also felt the need for recognizing the environmental rights as part of human rights, and they evolved a principle that there is a necessity to protect the right of life, which includes right to healthy environment. Whenever a second generation activity is evolved dealing with the socio-economic development, there will always be a conflict with the third generation rights, namely right to hygienic life. So they felt the need for creating equilibrium between the two so as to have a sustainable development for healthy welfare and prosperity of human beings. This was the first time in Stockholm Declaration of United Nations Conference on Human Environment, 1972, set forth that every man has a fundamental right to freedom, equality, and adequate conditions of life, and casts a solemn responsibility on each individual to protect and improve environment for the present and future generation. They agreed upon the declaration containing 26 principles governing the environment and development and action plan with 109 recommendation resolution, some of which I extract which are relevant for our purpose. Principle 2, the natural resources of the earth, including air, water, land, flora and fauna, and especially representative samples of natural ecosystem must be safeguarded for the benefit of the present and future generation through careful planning and or management as appropriate. So it is clear from this that the convention has recognized the necessity of protecting natural resources and the responsibility of the government and public to use the natural resources in a scientific manner, not only to meet the present generation need, but also to protect the same for the benefit of the future generation to come as well, which gives an indication of creating a public trust to protect environment for the purpose of present need with a responsibility to hand over the same for the beneficial enjoyment of the future generation as well. Principle 4 says man has a special responsibility to safeguard and wisely manage the heritage of wildlife and its habitat, which are now gravely imperiled by a combination of adverse factors. Nature conservation, including wildlife, must therefore receive importance in planning for economic development. This also casts a responsibility on the state as well as the people to protect wildlife, its natural habitats, while considering the question of economic development and industrialization. Principle 8 says economic and social development is essential for ensuring a favorable living and working environment for man and all for creating conditions on earth that are necessary for improvement of the quality life. They considered the necessity for economic and social development so as to improve the quality of life of the people, thereby evolving a principle of sustainable development so as to provide economic and social development, reminding the responsibility to protect environment as well. After the Stockholm in 1972, followed by Rio de Janeiro in the year 1992, there also they have considered the necessity for integrating the states of the world on the question of development in coexistence with the protection of environment. Their principle 1 says human beings are at the center of concerns of sustainable development. They are entitled to a healthy and protective life in harmony with nature. That also gives an indication that sustainable development must coexist with environment protection, otherwise it will have greater impact on human life. Principle 10 says environmental issues are best handled with the participation of all concerned citizens at the relevant level. All the national level, each individual shall have appropriate access to information concerning the environment that is held by public authorities, including information on hazardous materials and activities in their communities, and the opportunity to participate in decision-making process. States shall have facilitate and encourage public awareness and participation by making information widely available. Effective access to judicial and administrative proceedings, including redress and remedy, shall be provided. This gives an intimation that the government has got a duty to create awareness among the people regarding their responsibility to protect the environment. It also imposes a duty on the government to get public opinion before starting an hazardous industry so as to consider the pros and cons of establishment of the industry on environment and how remedial measures can be taken for maintaining equilibrium between development and sustaining the ecosystem and preserving and conserving the natural resources from being overexploited. Here comes the principle of public awareness and also public participation in protecting the environment. On the basis of the convention, being a signatory to the convention, the India thought of introducing certain amendments to the Constitution by way of amendment, 42nd Amendment in 1976, and Article 48A and Article 51A were incorporated. Article 48A deals with the duty of the state to protect environment. The protection of protection and improvement of environment and safeguarding the forest and wildlife. The state shall endure to protect and improve the environment and to safeguard the forest and wildlife of the country. Though it is included in Part 4 of the Constitution as directive principles of state policy, it gives an indication that there is a responsibility on the government to protect and improve environment and also safeguard forest and wildlife in the country. Though it was not having the force of fundamental right with a right to enforce the same through court, but courts have interpreted the provision in such a way as to treat the same as a fundamental right of the people to enforce their right to life provided under Article 21 of the Constitution of India, as a right to life includes right to healthy life for which healthy environment is required. That is, providing clean water, air and environment was regarded as part of the right to life as enshrined in Article 21 of the Constitution of India. For the first time, by 42nd Amendment, fundamental duties were incorporated. Till then, we have got only fundamental rights. No duties were imposed on us. And we have the relevant portion which regard to environment is Article 51 capital A G, which reads, it shall be the duty of every citizen of India to protect and improve the natural environment, including forest, lakes, rivers, and wildlife, and to have compassion for living creatures. By this, a duty by way of moral responsibility and also constitutional responsibility was cast on the people to protect environment, as without environment, their survival on earth will be difficult. Thereafter, Parliament has passed Water Prevention and Control of Pollution Act 1974, Forest Conservation Act 1980, Air Prevention and Control of Pollution Act 1981, and lastly, Environment Protection Act 1986. Till then, there were no laws which governs the environmental protection at all. Environment Protection 1986 was passed as an umbrella of general law to protect environment, as they thought that the existing laws are not sufficient to meet the need. Invoking Section 5 of Environment Protection Act 1986, several subordinate legislations by way of rules have been passed in respect of protecting environment to guard against overexploitation of natural resources. Till 1994, there was no law governing environmental impact as a part to be considered before considering a new industry. Environment Impact Assessment Notification 1994, shortly known as EIA notification, was passed by which establishment of certain categories of industries were brought under the regime of obtaining prior environment clearance. Before granting the clearance, environment impact assessment study will have to be conducted by the project proponent. Only thereafter clearance can be granted for establishing such industries, imposing some special, specific or general conditions as a precautionary principle to protect and preserve environment that will take care of protection of environment against pollution, both air and water. Air pollution includes sound pollution as well. As later it was found that excessive sound will have impact on human life. Later, the Environment Protection Act, the environment assessment notifications were amended in 2009, 2006, 2009, 14 and 16. Now 2020 draft notification is under consideration of the central government, which you have now understood that there are a lot of oppositions regarding some relaxations made in the notification and which requires public consultation and also because in some of the industries or in establishment of industries for obtaining environment clearance, the necessity of public consultation as was taken away. So that made a hue and cry by the political parties and also the environmentalists. And now it is under the consideration of the central government. We do not know what will be the outcome of the 2020 notification regarding the environment impact assessment. Thereafter, Noise Pollution Regulation Control Rule 2000 was passed to regulate the mechanism for prevention of noise pollution. Biodiversity Act 2002 and Coastal Regulation Zone Notification 1991, 2011 and 2019 were also passed with a view to protect biodiversity and over-exploitation of the biodiversity available by the beneficiaries, and certain regulations were made. And also to protect coastal zone, some regulation is required as insisted by the international covenants and also by the Supreme Court in several cases, that protection of coastal zone is also required, as pollution caused to marine is also have impact on the environment and also the day-to-day life of persons who are solely depending on the marine products for their livelihood. By a subordinate legislation, solid waste management rules, biomedical management rules, hazardous substance management rules, plastic waste management rules, construction and demolition management rules, and similar rules were also passed in order to control all possibility of pollution being caused on account of sources which are likely to be identified as sources of pollution. All these rules fixes a responsibility on each stakeholder from the generator up to the regulator as to what are all the things to be done by each stakeholder for effective implementation of these rules. Under the Environment Impact Assessment Notification, certain activities were brought under the regime of getting environment clearance. Prior to starting of certain industries specified in the schedule attached thereto, there was also a procedure provided including assessment of environment impact by the expert appraisal committee before granting the environment clearance, so as to minimize the impact of these activities on environment within the standard prescribed. These are all intended for the purpose of protecting environment against pollution. Certain category requires public hearing as well. Thereby, the opinion of the public on the impact or apprehension of the public regarding the impact on environment on certain activities has to be considered by the project proponent, and he will have to give remedial measures to overcome those apprehensions, and that will have to be incorporated as a condition in the environment clearance to be granted, so that those things will have to be monitored by the regulatory mechanism and make the project proponent to adhere to the conditions in its letter and spirit. Wetland Act and wetland rules were also passed in order to protect the wetlands in the country, which plays a greater role for maintaining the equilibrium, that is biological equilibrium, and also to protect against exploitation and pollution of water bodies. Certain restrictions were also imposed under the above act and rules regarding establishment of certain units, and certain regulatory measures were also provided for such purposes. Because the purpose of water bodies is not only to provide drinking water and also water for irrigation. In fact, they act as a water reserve, the conservation unit, I can say, and which will help the recharge of groundwater level in the area. Thereby, the underground groundwater level will always be maintained, so that you will be getting water and on any occasion without any scarcity. If that is dried, what will happen? Because you won't get water. That is how we are now suffering. Because now the water bodies have been encroached, stating that due to want of water in the water bodies, they feel that so much land is not required for the water bodies preservation, and people are encroaching into those areas and constructing buildings and also using those water bodies, part of the water bodies which is not covered by the water as dumping grounds as well. Thereby, when the rain comes, you don't have any place to collect water, thereby the neighboring areas being inundated by water, submerged in water, causing damage to the human life as well. There lies the responsibility of the people to see that the water bodies will have to be protected, as they not only give water but also protect their groundwater recharge level to provide water for any time to come in future as well. The Honorable High Court, the Supreme Court has played a great role in protecting environment by giving necessary direction, invoking the jurisdiction under Article 32 of the Constitution of India for the purpose of protecting environment, as clean environment was declared as part of right to life as enshrined under Article 21 of the Constitution of India. The Honorable Apex Court also evolved environmental jurisprudence by creating certain doctrines like doctrine of public trust, sustainable development, polluters pay, absolute liability with a view to protect environment, and also to implement the directive principles of state policy as contemplated in Article 48A and 51A of Constitution of India. Definition of forest was also expanded to protect forests from overexploitation. There was a thinking among the people that when it was not a declared forest or a reserve forest, or if it is not a protected forest and by way of any notification by the government, and revenue records, if it is not mentioned as forest, but known in some other name, people thought that they will not come under the protection of the Forest Conservation Act, and that can be used at their whims and fancies. But due to the intervention of the Supreme Court has expanded the meaning of forest with its grammatical sense, and in the generic sense it is being known under the public parlance as to how forests are being viewed or understood by the people, and give a greater expansion of its definition, stating that irrespective of the nomenclature provided in the revenue records, if it is a forest cover of a particular area which is deemed to be or which is being treated as forest or a green cover by the people with certain species of trees, not a spontaneous growth, but as a certain species of trees which greater extent, then it will be deemed to be forest, and that was brought under the provisions of the Forest Conservation Act 1980, and it was felt that whenever that area will not be converted for non-forest purpose, then permission from the forest department authorities, which includes a expert body to go into those aspects, and before granting the clearance, and only with the clearance being provided, the project proponent or the government, including the government, can proceed with the project. Otherwise, they may not be able to destroy the forest. And when such things are being done by the forest department and the forest ministry, they used to impose the afforestation policy, thereby getting equal number of area for the purpose of replanting the distracted forest for the purpose of the non-forest activity, thereby to maintain the green cover without reduction. So I am summing up regarding the role of the government as well as the public in protecting environment. It is clear that the government as well as the public have got a great role to play in protecting environment. As far as the government is concerned, there is a duty cast on them under Article 48 of Constitution of India to protect the environment. Unless the laws passed by the government were strictly implemented by the state with modalities, the purpose intended by passing such protect environment will be in vain. The government has got a role to play before establishing industries as part of their development activities to provide employment and also to improve economy. They are expected to conduct an environmental impact assessment study by appointing an expert committees to ascertain as to whether the Mother Earth has got the capacity to sustain such a large-scale development maintaining the doctrine of public trust, sustainable development, and precautionary principles therein. Here comes the decision of the Supreme Court in Deepak Kumar's case when dealing with the mining projects. The Supreme Court has said that the impact assessment has to be conducted because earlier, for less than 5 hectares of land for doing mining, there is no environment clearance is required. Thereby, what the people were doing was the large area of the property were divided into small portions, less than 5 hectares, to escape from getting the environment clearance, and thereby they need lease that is provided by the mining department for the purpose of doing the act. That part of the act of the government as well as the mining department was deprecated by the Supreme Court and said that even if it's less than 5 hectares of land, if it relates to exploitation of natural resources, you will have to conduct, must be brought within the regime of the environmental laws of getting a prior environment clearance before starting the project. And also said that even if it is less than 5 hectares of land where public hearing is not required, sometimes because it is come under the B1 category or B2 category, where by virtue of the EIA notification 2006 and 2009, public participation has been taken away. And it is only for the Environmental Assessment Authority to go into those aspects and provide certain conditions for protecting the environment. The Supreme Court has come to the rescue of that. Even if there is no public hearing, you will have to have a cluster environmental impact assessment before granting the environment clearance on smaller plots of land, as to verify as to whether how far the replenishment capacity of the natural resources are available for exploitation. Only after making a study of such aspects, then only you will have to grant, because you will have to fix the quantity which can be extracted so that the natural resources can be, over-exploitation can be protected. The natural resources will be available not only for meeting the present day need, but also for future generation to come also to enjoy. They are also bound to follow the procedure in its letter and spirit so as to protect forest, wildlife before deciding to divert forest land for non-forest purposes as provided under the Forest Conservation Act. The government has also got a greater role to implement the regulatory mechanism provided under the pollution laws through its regulating agencies to prevent pollution being caused to air, water, and environment, and take appropriate action against the violator by imposing heavy environmental compensation, applying the polluter pay principle, and also to take remedial measures to restore the damage caused to environment to its original position, applying the precautionary principle. Here, the role of Supreme Court plays a role of principle. The Supreme Court as well as the Green Tribunal plays a great role, because earlier the pollution control boards were of the view that they don't have power to impose environmental compensation. The Supreme Court has come to the rescue and said that whenever it is found that there was damage caused to environment on account of an hazardous substance that is being used by an industrialist, then there is an absolute liability on the polluter to pay damages. Not only that, the damages must also include the concept of restoration of damage being caused to the environment, for which the remedial measures will have to be taken by them. That is how it has been evolved. And following the directions of the Supreme Court, the National Green Tribunal has directed the MOEF and Central Pollution Control Board to come with a formula as to how the compensation will have to be imposed on the persons or the industries who are violating the environment laws, thereby causing pollution to environment. And now thereafter, they have evolved a formula that has been published and that has been circulated, and that is having the effect of law now under Section 5 of the Environment Protection Act, as 5 of the Environment Protection Act gives a power for the government to evolve certain direction to be issued for the purpose of protecting environment. though there are only two directions provided, the closure and also the remedial measures, but it is not an exhaustive definition of giving power, but is an inclusive definition. So that was interpreted by the National Tribunal, saying that there is already a power under Section 5, which can be utilized by the Central Pollution Control Board, and they can evolve the policy and they can issue notification in this regard. And now the notification has already been issued, and it is on that basis the Pollution Control Board itself is taking action whenever it is found there is pollution caused to environment, that is by polluting the river, polluting the air, or causing sound pollution, etc. They are imposing environmental compensation, applying that principle, making the industries to pay the amount, so that will give a message to them that whenever they violate, they cannot simply go by getting certain directions from the Pollution Control Board to upgrade their institutional mechanism, but they will have to financially liable to pay compensation to restore the damage caused to the environment by spending out of their profit, thereby reducing the profit. So making pollution makes the industry a non-profitable one. So they will be afraid of polluting the industries. That will give a message to them that they have got a duty to implement the pollution mechanism that has been provided under the statute in its letter and spirit, as the responsibility to protect environment is not only on the government, but also on the project proponents who are conducting the industries. Further, the government has also got a role, not only enacting laws, but also to make public awareness about the responsibility of the people also. The Supreme Court, in one of the cases, in MC Mehta's case, in series of decisions in that case, imposed a responsibility on the government to make the awareness of public regarding their role in protecting environment. They also said that they will have to evolve or incorporate, or they will have to take the participation along with the legal service authorities for the purpose of educating people on this aspect. And they will have to not only to educate the people, but also to educate the stakeholders, including the regulatory mechanism who are implementing the law, about their responsibility to see that how far they are duty bound to protect, not only by the statute, but also by the constitution, to protect environment by implementing by enforcing the implementation of these pollution laws in its letter and spirit. There is a duty also caused on the public, as they have got a fundamental duty to protect environment as directed under Article 51G of Constitution of India. They are bound to follow the procedure provided under various waste management rules in order to curtail the generation of source of pollution to sustain development. See, here I want to say, keeping your house clean is not sufficient. You will have to make the surrounding also clean. That gives an importance regarding the introductory manner in which the subject has been introduced by the former speakers, that putting the garbage on the drains, chalking them, and thereafter saying that the municipality is not doing anything or corporation is not doing that. Who is the responsible for doing that? We are responsible. So we must understand our responsibility, that you are not expected to throw it on the drain. Once you throw it, it will choke. When it is choked, what will happen? The free flow of sewage to the water, the treatment plant will not go. It will be blocked there. It will overflow on the road, that create havoc by creating diseases. Even pandemic diseases, we can say you are afraid of dengue and other thing. Why? The creation, you are creating source for brooding mosquitoes. So if you can avoid such possibilities by using your brain or using your responsibility to protect environment, and avoid such things, littering of things and throwing away the garbage on the road, then you are doing your duty, you are contributing something. When the Setu Bandhan was constructed, during that the squirrel wall was also going and falling in the water and coming to the and rolling down, saying that when it says what you are going to do, what else can you do? He said, I can do whatever I am possible, because the some amount of sand that I am spreading on the rock will give help for joining the foundation, so that the smooth the construction of the bridge can be constructed. So that is the way in which our attitude comes. Small drop water can make ocean. So whatever thing that small things possible by the public, if they can able to do it, that will have a great importance. That will play a great role in protecting environment from your side. They are also expected to take measures to minimize the generation of waste by avoiding using such sources which are likely to affect environment at a larger scale. The public has got a duty to participate in the consultative process when new industries are established in an effective manner, so that all possibilities of pollution can be brought to the notice of the authorities, which will enable them to make a proper environment impact assessment before granting the clearance, and also to impose conditions to minimize such impact on this environment. Here I want to explain certain things more, because if you go by the solid waste management rules and the biomedical waste management rules, it provides certain basic procedure has to be followed by every person, because they say the solid waste management rule says that the generator of the waste, that is a household, they will have to segregate the waste into biodegradable and non-biodegradable into two parts. And the biomedical waste is also being used, because people are now using that what you call sanitizers and masks nowadays. So you will have to segregate those things and keep it in different containers, so that the persons who are collecting it, that is a mechanism provided under the statute, that the door-to-door collection will have to be done by the corporation or the local bodies, and it will be easier for them to send those things for the purpose of disposal in a scientific manner. Biodegradable waste can be sent to the compost unit, thereby they can convert into manure, which can be used for the purpose of agriculture and other purposes. Biodegradable waste can be segregated by them, reusable things can be reused, recycled things can be recycled, and the remaining waste can be used for some other purpose, for creating the refuse oil, which can be used for the industries as well. So thereby, the scientific method by which the waste can be managed, and thereby you can contribute your responsibility of discharging your constitutional obligation of protecting environment, and thereby helping the regulating authorities also to do their responsibility in an effective manner. And as far as the educational purpose is concerned, the universities and the upcoming lawyers, I can say, have got a greater role to play, because the people are not aware of the laws. Unless they are educated about the existence of laws and what are all the laws dealing with protection of environment and their responsibility to protect environment, they may not be knowing about those things. And everybody think, including ourselves, that it is a duty of the government to do everything. There is a duty cost on the government to protect environment, to provide clean water, etc. But forgetting our responsibility of contributing whatever possible from our side to protect environment. So the law institutions, I can say, must take it as a challenge or as a part of their professional career to spread the environmental education to the people, so that people may also understand their role in participatory as well as contributory to protect environment. Participatory, I say that whenever public consultation is required for the purpose of granting certain type of industries which have a greater impact on environment, then your participation, expressing your views on pros and cons of the possibility of pollution, will give an eye-opener for the project proponent to say that it is not an easy thing to run an industry, but he has got a responsibility to take more precautionary methods, upgradation of their units for the purpose of providing mechanism to avoid pollution as well. So thereby, the public participation is also plays a great role in protecting environment, for which people will all be educated by the person capable of doing it, which can be done only by the law universities with the assistance of the legal service authority, so that the environment, because there is no procedure by which you are only taught that civil laws are being taught in the Legal Service Authorities Act. Nobody is taking care of providing environmental education to the people. So unless now people are understanding the need for an environmental education, that is reason why the webinars like these things are coming up. with an idea of educating people on this subject. So once that subject gets an importance and people get wider idea about their role also, for example, the solid waste management rules, what they will have to do, people may not be knowing about it. Even if you provide a bin to them, they will put everything in one. Everything will be mixed. Once it is mixed, it is very difficult for them to segregate and send it to the different areas where it can be easily disposed of in a scientific manner. But these people also will put it in, dump it in a ground. Even in a place where I think that your university, Perungudi, the Perungudi dumping ground is a headache for us. And we are giving directions to the corporation and other people to see that the legacy waste that has been put there will not be discharged or disposed of in a scientific manner, so that the nearby water bodies can be protected. Because once a leachate is created on account of dumping of these things there without treatment, then there is a possibility of percolation of that leachate into the ground, affecting the groundwater. Thereby, when it comes to the drinking water purpose, you are taking a polluted, contaminated water without knowing that you are drinking poison. So these are all the ways in which you can also have interact with the corporation or the regulating authorities so as to make the rules implemented in its letter and spirit. So with these words, I conclude with saying, it is clear from the above that the both government as well as the public have a great role to play in protecting environment. Unless they understand the need of protecting environment, which is a basic necessity for survival of human being in the universe, and discharge their duties and obligation, then they will have to face the disasters of calamities which ultimately affect the existence of human life itself. Any development detriment to the human interest will be of no use. They will have to strike a balance between the development and protection. So let us work together by discharging our respective roles in protecting environment and have a healthy and prosperous life. I conclude with the quote from Tirukurar, Karka Kasadara Karpavai Katapin Nirka Adarka Tagar. So mere learning as to how to protect the environment is not going to help us, but you will have to practice in your life also as to how this will be done. Once you've done that, we will be doing discharging our responsibility. We can save Mother Earth from over-exploitation, and Mother Earth will always shower his blessings on a subject to give a healthy environment which is required for our day-to-day life. Thank you very much for the patient hearing and also the opportunity given to me by the university for sharing my thoughts. I can only say that sharing my thoughts as to how the government as well as the public will have to play in protecting environment. Thank you very much.
Thank you, sir. Thank you, sir. That was a very, very informative session. And the pain taken for the PPTs prepared. I think I must thank you from bottom of my heart. Even we academicians don't do this, sir. Thank you. Thank you so much, sir. On behalf of all, I am telling this. Thank you, sir.
Thank you.
Can we take up some questions, sir?
Okay.
Yes, sir. The moderator will be taking from the chat box and she will be narrating. Yes, sir. Over to you, Aishwarya.
Thank you, Lordship. It was indeed a very, very enlightening session. It felt as though we were sitting in class and listening to the session. Thank you so much for this wonderful lecture, Lordship. Ashwin Suren will be moderating the question and answer session for us. Over to you, Ashwin.
Greetings, Your Lordship. With your consent, may I open the floor for the questions?
Hello.
We have
Proceed.
a question. Your Lordship, may I open the floor for the questions?
Yes.
We have a question from Mrs. Sheila Rani with regard to the impact of electronic waste in our environment and the laws against it.
So there is already an e-waste management rule which provides the mechanism as to how the e-waste will have to be managed. So there is already a rule in 2016 which gives those things. Each generator, because there is an the extended producer's liability, there is a provision provided there Thereby, the person who is producing these electronic articles also has a responsibility to collect them when it has become useless and see that they will have to cooperate with the regulating authorities for the purpose of destroying the same in a scientific manner. Otherwise, it will have greater, because now you are going on electronic era, because instead of you are going for what you call paperless office, thereby depending on the electronic machine for all those purposes. So after some time, because every time it is likely to be changed, and after some time it will become outmoded and you will have to go for new one. So what we will do with this? So you will have to find a via media as to how the old things, as what we are doing in the olden days, how the whole things will have to be collected by some people, and some exchange of some useful articles will be given, that will be reused or recycled for the purpose of what all the possible things that can be used can be reused for for manufacture purpose. All other things can be not be disposed of in a scientific manner, so that the possibility of pollution being caused on account of electronic technologies can be controlled. Because the central government, because the National Green Tribunal has given direction to the MOEF, because the people were under the impression that though EPR is there in the rules, there is no guideline provided as to how this will not be implemented by the generators or the manufacturers or dealers. They think that they can providing certain amount of money will be sufficient, or creating some CSR will be sufficient for that purpose. But we said no, it is not sufficient. But you will have to provide a mechanism as to what they will have to do. What are all the, just like they must have a collection center where these things can be provided. The dealer will have a responsibility to collect whenever the people are coming for new article. If the other people, the person who is purchasing a new article want to dispose of his old article, they must collect it and see that it has been sent to the disposal center, and it will not be dealt with in a scientific manner. So that EPR, if the EPR is implemented as provided under the rules, I think to some extent we can solve the problem. The Green Tribunal as well as the ministry is working on it. We hope that in the near future itself, some guideline will come from the Central Pollution Control Board as to how the EPR will be implemented.
Thank you, Lordship. I think due to the time constraint, I can restrict myself to few questions. And the next one is from Shaji, who's asked you a question with regard to environmental crime, Your Lordship.
See, as far as the environmental crime is concerned, the Pollution Control Acts itself provide the mechanism, because each violation gives rise to a crime. Though people are not aware of the impact of environmental crime, in fact, it is more harmful than murder. Because as far as doing murder, if you analyze the mind of the perpetrator, there must be some motive for it, or there may be something for him to retreat. But as far as the environment crime is concerned, which causes death, because in Visakhapatnam, when the Geese Lake came, innocent people, there were loss of innocent people's life. Who is responsible for that? And how they are going to be punished? Because in Bhopal tragedy case, because of there is no provision for severe punishment, that come under as a criminal negligence under section 304A. Thereby, they were punished only with a lesser punishment, though large people have suffered grievous injuries, also death has also caused. So that will not be taken out of by the legislature for providing more stringent punishment. And if you go by the Environment Protection Act, I think that section 19 deals with the prosecution. And the the pollution rules, the Air Pollution Act, Air Act and Water Act also provides punishment. If you go by the punishment, though it is a magistrate court, stringent punishments were provided. For recurring offences, graver punishments were provided. So how far the prosecutions were launched is a question. When there is no prosecution launched, because people are not aversion to the prosecution, because burden of proof is more on them. So the prosecutor, they may not, suppose if there is a lacuna in the technical way in which the sample will not be collected, or the process will not be done, or the complying with the procedure provided, then that will be interpreted in favor of the accused, so they will go scot-free. But that doesn't mean that the prosecution should not be launched. See, you will have to launch a prosecution when the law provides for launching prosecution. Once there are prosecutions are launched, they will feel that going to the court and facing the criminal prosecution is not that easy. And the environmental courts dealing with environmental crime also must give education as to how the environmental crimes will not be dealt with. Because in forest laws also, you can't insist for evidence that is being available regarding as to the eyewitness, etc. The forest offense will be committed not with the eyewitness in the presence of witnesses. Maybe there may be conspiracy among the persons who are doing it. There may be that is being done with the persons who are doing it. But it will be detected after some time by the forest authorities. Thereafter, tracing back to that and with some scientific method, when the articles are traced, the person in whose possession those articles were found were brought before law, and they are being punished. So when you are analyzing the evidence on such aspects, how the environmental court imposed with the duty of protecting environment, also will have to think about the stricter vigor of the evidence, appreciating evidence. And to some extent, I will say that the probabilities will have to be gone into in those things, as in the case of civil liability. But at the same time, it is not the all probabilities, but stricter principles will have to be followed to point out the crime-made person for the purpose of convicting him, because innocent person should not, because for want of evidence or want of no legal evidence, no person should not be punished, because that is the principle. Even 100% go scot-free, no innocent person should be punished. That is our criminal jurisprudence. That will have to be gone into. But when you apply the stricter principle, and to some extent, by amending the provision, I can say the res ipsa loquitur provision has been incorporated in criminal procedure, at least in environmental protection laws. I think that to some extent, the burden of the prosecution to prove the guilt in environmental crime to its beyond reasonable doubt can be reduced, and the burden can be shifted to the person who is polluting to say that he had taken all the precautions. It is beyond his possibility that it has happened. So thereby, some fear will come in the mind of the people who are committing the environmental crime, deterring them from repeating the same. This is only my personal view. That is for the lawmakers to think about how the defense will have to go. Because in certain legislations, there is a presumption. It starts with a presumption that you have committed the crime. It is against the general principle of criminal jurisprudence. And the burden is on the accused to disprove it. Once he had by the reasonable doubt, he has been able to discharge his burden. Again, it shifts to the complainant to prove beyond reasonable doubt. So only thereafter the question of beyond reasonable doubt goes. Otherwise, it proceeds the presumption that you have committed the crime. You are liable to face the consequences. So that way, I think that in environmental crimes, the principle of presumption of innocence will not be taken away, and the presumption of commission of crime will not be incorporated, and that is for the legislature to do it. I think that it may, after some time, that regime may come. Till then, we will have to go by our general principles available as to how the crime will have to be proved, etc.
Thank you, Lordship. I think I'll ask the last question. There are many of our participants who have asked regarding the EIA 2020 draft. So could you please share a few words with regard to that, sir?
See, the purpose of EIA notification itself, because till 1994, there is no provision for assessing environmental impact at all. Because the concerned departments decides what is the methodology by which the industry will have to start. And if it is coming under the pollution control laws, then the pollution control board, the Water Act and the Air Act provides certain procedure for obtaining certain consent from the authorities before starting, because consent to establish is required for certain categories, and combined consent to establish and operate can be given for certain type of categories. The consent to establish itself provides certain conditions as before establishment, what are all things to be done. Only if those things are satisfied, then the consent to operate will be given. Only on that basis, the industry can operate. For the first time in 1994, after the introduction of the Stockholm Principle, everything, what happened was Environment Protection Act was passed. Thereby, the Environment Protection and the Environment Impact Assessment Notification was issued in 1994, attaching a schedule incorporating certain categories of industries requires the environment clearance. And they also provided that for the purpose of granting environment clearance, there is a duty cost on the project proponent to provide the impact assessment report study conducted by him. That report will also form part of the the application. Then on that basis, the department will decide whether which category, whether the state government will have to provide, the state machinery will have to provide the environment clearance, or the central government will have to do it. And in that basis, it will be bifurcated. It will be sent to them. Necessary terms of reference will be given to the project proponent to evolve the mechanism by which the possible the pollution that is likely to be caused to the environment. And on that basis, certain categories require public hearing. So the environment impact assessment that has been a report that has been prepared by the project proponent will be put to the public domain, and the Pollution Control Board have to conduct a public hearing within the vicinity of the area where the industry is going to be proposed, because the immediate affected persons will be the persons who are residing nearby. So the views of those people will have to be heard, and the apprehension of those people as to how this is likely to affect the environment, how it is going to affect their day-to-day life, and how it is going to affect their livelihood itself sometimes. Because if the agricultural lands are being used, if there is a possibility of groundwater being taken more than the availability, then it is have an impact on their day-to-day life itself, because there will be a scarcity of water, which will deny the drinking water for those people. So those things will have to be taken note of in the public hearing. And in the public hearing, the project proponent will have to give his remarks on those things, how he is going to improve that. That also will be taken into consideration by the expert, all with the public opinion, and also the views given by the project proponent will be forwarded to the expert appraisal committee. The expert appraisal committee will consider all these aspects, and thereafter they will decide as to whether the project will not be recommended or not recommended. If at all it will not be recommended, then what is the conditions under which this can be done? And this will be sent to the authorities who have to grant the clearance, and that authority will look into that, and thereafter only with a specific or special or general conditions, the environment clearance will be granted. And there is a mechanism by which they will have to monitor these things, whether the conditions imposed are being properly monitored, being implemented by the unit. And if it is not done, then action will be taken by the authority. Even they can even revoke the clearance granted, or even temporarily close down the industry till the conditions are improved. To make the industry, working of the industry eco-friendly. But later on, what happened was, by I think that the apprehension in the 2020 notification is, because I am not expected to express my views on this at this stage, is likely to come even before us sometimes. See, the apprehension of the public, what I understood is that the large-scale relaxations have been made, thereby taking away certain type of industries out of the regime of the environment clearance itself. Because earlier, the multi-storied projects, the construction projects were coming under the regime of getting environment clearance if the total constructed area exceeds 20,000 square meters. Now I think it has been enhanced to 1,500 square meters, and up to 1,500 square meters, there is no necessity for an environment clearance. They need only go for the consent mechanism provided under the Water Act and the Air Act. So that is the one apprehension by the people. And secondly, the public, for some categories, public hearing was dispensed with. So if public hearing is, because even my lecture also I said, the international covenant says that the public awareness must be there, public consultation must be there for the purpose of ascertaining the views of the people on the impact of environment on a project. So if that right from the public is taken away, whether it is proper or not is a matter to be gone into legally also, or judicially, and also in a constitutional manner also. So those are all things, larger aspects, which threatens the minds of the people, creating apprehension that if such the act, the notification as such comes, it may have great impact on environment. Even the former Minister of Environment has said that it has not properly done. The assessment, if you take away certain industries and the public hearing is dispensed with, a havoc will cause. Thus, I want to repeat what our Vice Chancellor has said. Making a speech will be easier. Saying that protect environment is our primary responsibility. But when it comes to the implementation, how far you are doing it in a constitutional mandated way, and also as a part of the signatory to the international covenants, balancing the sustainable development with the environment, protection of environment, that will not be gone into, because people are thinking that the development is required. But when overdevelopment comes, which is not useful to the public, and it is determined to the public, who is going to enjoy the benefit? No one will be there on the earth to enjoy it. If such a development is required or not is a question for which the public will have to answer. Not us, not me for the time being, because public opinions have been called for. I think I saw from the newspaper today, more than a lakh of objections have been received by the ministry. Let us wait for the ministry's indulgence as to how this will be viewed by the ministry, and hope that it will be taken care of by the ministry when the anticipated notification comes, with taking into the role of the government. I can say that protect environment is a primary responsibility of the government when comparing the development, because any development against the detriment of environment is of no use. That will go against the principle of sustainable development itself. Yes.
Okay, thank you very much, Your Lordship. You've answered all the questions quite elaborately. We've had an overwhelming number of people asking a lot of questions, but we've crossed our time limit. So I'd kindly say that.
I think that it will be better if you have got an open platform so that we can entertain a large number of questions, because of want of time here, and we are not able to do it in an effective manner.
Yes, thank you very much, Your Lordship.
Anyhow, thank for the university, at least for arranging such webinars. To some extent, we can able to exchange our views, which will be helpful to for the university as well as the public also to know about the responsibility and implement in the right perspectives.
Thank you very much, Your Lordship, and thank the participants for asking such intriguing questions. Thank you. Over to the moderator.
Thank you, Ashwin. One of my favorite Tirukkurals is Tirukkural 411, which is Selvathul Selvam Sevichelvam, Achelvam Selvathul Ellam Thalai. Thank you, Lordship, for enhancing our wealth by delivering such an excellent session. Our Vice Chancellor, Professor Dr. T.S.N. Sastry, would like to speak for a few minutes. Over to you, sir.
Thank you, Honorable Justice, for accepting our invitation and sharing your valuable thoughts. In fact, it was a memorable lecture. You have covered the vast, important perspectives from public point of view, from legalistic perspective. And this is what I am advocating for the last 2 years in my reason, that the gap that is there between bench and bar has to be fulfilled this way, to get in the touch with. And thanks to COVID that we have got this type of wonderful opportunity. It is not restricted only to classroom or a seminar hall, dates, this, that. It is a wide open platform for anybody to listen. I think this is a wonderful opportunity, and we will work with you, sir. And as I said in the beginning, I think my HOD and others will come out with a proposal since the university is already asked to represent one of the members in the commission. and we will take up more practical oriented approaches than theoretical or research perceptions alone. And I thank you once again, sir, for kindly accepting our invitation. Looking forward to have more number of programs or projects with the university. Whatever we can do, we will help you. You can count on the university at any point of time. Thank you. Thank you very much.
Thank you very much. Thank you very much.
Thank you, sir. I now invite Professor Dr. P. Shaktivel, HOD in charge of the Department of Human Rights, to deliver the vote of thanks.
Good afternoon. Am I audible to you, Aishwarya, everyone? Yeah. Good afternoon. It's my privilege to propose this vote of thanks. On behalf of the organizing committee, I thank Honorable Justice K. Ramakrishnan, Judicial Member, National Green Tribunal, for accepting our invitation to deliver this lecture on the role of government and public in environment protection. So the lecture is informative and thought-provoking. A lot of students and practitioners had doubts about the interlink between human rights and environment. I guess this lecture should have cleared all their doubts. And Lordship has covered from ancient days to this present EAA draft. In a way, this lecture is a kind of introduction to the whole of the functioning of the environmental laws in India, and especially from your expertise and from your experience, you gave a lot of insight to us. Thanks a lot, Lordship, for sharing your thoughts and also accommodating our questions. In fact, the question answer session was very nice. Almost we are able to accommodate only few questions, but you made the answers were really. Yeah. I think I lost Judge back. So I also thank our Honorable Vice Chancellor, Dr. T.S.N. Sastry, who is always motivating. Thanks a lot, sir, for your presidential address and also a concluding remark. We sincerely thank Professor Balaji, sir, Director of School of Excellence in Law, for his friendly and generous introductory words. He is always motivating us. I always thank Dr. Harita Devi, ma'am, HOD in charge of this Department of Environmental Law, for her sincere efforts. She's always taking efforts to do certain programs, taking care of the department faculty. Thanks a lot, ma'am, for these efforts. I must thank Aishwarya, moderators, and our IT team for their work. Almost today we have seen 350 participants in this program attending through WebEx platform, and in YouTube we have seen more than 50 people. That is almost more than our auditorium strength. So it also took a lot of effort from our home. So so thanks a lot, sir. Thanks a lot, everyone, for this. And also, I received many calls from the practitioners of Green Tribunal after the release of this brochure. Many of them registered and participated in the webinar also. We are happy to have served the bar as per the instructions of our Vice Chancellor, and we sincerely thank all the students and academic fraternity across Tamil Nadu. A lot of teachers have also taken part in this webinar. We thank everyone who participated in the seminar, in the webinar, and we would say that this proceedings will be available in the YouTube, so anyone can watch it. Thanks a lot.
Thank you so much, sir. With this, we come to the end of the session, and I would like to remind all the registered participants to fill in the feedback form, the link for which is available in the chat box of the Cisco WebEx app. It will also be available in the description box of the YouTube video. The certificates will be processed in a couple of days, and it will be sent to your registered email. With this, we come to the fag end of the session. I thank you all for your patient listening, and thank you, Lordship, for the entire session.
Thank you.
Thank you, sir. Thank you personally on my behalf and on behalf of my university.
I will have to thank the university for giving me an opportunity to interact with the people.
Thank you, sir. Thank you.
I always feel that I'm part of the faculty.
Yes. Expecting more interactions.
Sure.
Thank you, sir. Thank you.
Professor Arita. Well,
Aishwarya, feedback form is there, no? We'll wait for some time.
Yes, ma'am. We have already given the link, but some
Yeah, I
people
saw.
are asking for it again. Yes, ma'am.
Yeah,
I've
yeah.
copied
Send it
pasted the
again.
link.
Don't
Yes,
close
ma'am. I've
it now.
sent
Just
it.
wait.
Yes, ma'am. I've sent it.
Harita ma'am,
Yes.
I'm Lata. Nice webinar. It's the
Thank you.
necessity of the situation. It's
Thank
good,
you.
very
Thank you
good,
so much.
Harita ma'am.
Thank you.
Okay ma'am, bye.
Yes.
Harita ma'am, this is Rajalakshmi.
Thank you.
Congratulations, ma'am.
Thank you for
Congratulations,
joining.
Shaktivel sir. It was
Thanks,
well
Doctor.
organized. Well organized. Thank you. Very
Thanks a lot.
informative.
Thank you.
Sakti sir,
Can we disconnect the YouTube link now?
Let
Sakti
me
sir,
see,
this
sir.
is Lata.
Let me ask Arun, sir. He's actually operating. You're talking about YouTube?
Yeah, we can disconnect it.
Let me talk to him.
Yeah. So if anybody wants to talk something in between, let them talk because it's open now. Anyhow.
Yes.
Ma'am. Ma'am, I'm Gnanasekharan, Chairman of
Hello,
Mother
sir.
Chapter of ICSI.
Hello, sir.
Gnanasekharan,
Thank
Chairman of Mother Chapter of ICSI.
Yes, sir.
It was very informative and
Thank you, sir. Thank you.
thought-provoking.
Thank you.
Harita, this is Gauri here.
Yes, ma'am. Thank you for joining.
Congratulations and God bless you.
Thank you, ma'am. Thank you.
Okay, right. Bye.
Hello,
Hello.
ma'am. Am I audible?
Yes.
Ma'am, that was a good seminar, ma'am.
Thank you. Thank you.
Ma'am, but one of my doubts was not answered, ma'am. So,
That's fine. You just put it in our mail, sir. We'll try.
okay, ma'am. I have put it in the feedback form, ma'am.
Yeah, sure.
Okay, ma'am. Thank you, ma'am.
Madam, good afternoon to you. Hello. Hello. Hello.
Abhi கேக்குதா?
Yes, sir. We are able to hear you, sir.
Hello, Arita Madam, good afternoon to you. I am
Hello, Abhi.
Hello.
Hello.
Interesting and useful program.
Hello, sir.
Hello.
Sir, I
Hello.
couldn't find the feedback form, sir.
Let's go.
Hello,
Yes, ma'am.
sir.
Actually, calling from Government of Puducherry, the Department of Environment. Actually, just I would like to compliment organizing this program.
Thank you, sir, for your compliments. Have a nice day.
Thank you.
Hello, sir.
Ma'am, you can find the feedback form in the chat box, ma'am.
Chat. There is no chat box, but chat option is there, madam.
Ma'am, if you click on participants on the left side, you can find the chat box, chat with everyone. There we've given the feedback form.
I couldn't find, ma'am.
Ishwari and Suren.
Ma'am, hello. Hello.